So good afternoon, everyone. This is Web3 Tuesdays, and we have Nino Sievi today with us for a very interesting session on DAO disputes. As we were saying, this session is recorded and will be shared later on our YouTube channel. Nino Sievi is a triple qualified lawyer in Switzerland, Germany, and England and Wales. Who represents clients in complex crypto and blockchain disputes before arbitral tribunals and Swiss courts. He also serves as an arbitrator in international arbitration proceedings. He edits a newsletter on crypto disputes. I think one came out today, if I'm not mistaken. And he's a member of the expert group Justitia 4.0, which is tasked with leading the digitization of the Swiss justice system. As I was saying before, today we'll talk about DAO disputes, and without further ado, Nino, the floor is yours.
Thank you. I've always been a big fan of Web3 Tuesdays. I need to confess this. So it's a great pleasure that you've invited me here to speak today to you about DAO disputes. Probably shortly about my background. I've been active in crypto and blockchain disputes for the past 3 years, mainly in arbitration and a couple of state court litigations. So I do have first-hand experience of these DAO disputes, but there's one big disclaimer that I need to make. It's that all of these cases, although they have been messy and raised a lot of questions, they never have gone to verdict in the end. They have always settled at some point on the way. So as you will see, I will raise a lot of questions today. There's a lot of issues, unclarities, and unfortunately for you, I will not be able to provide you with any definite answers. So this presentation is basically going to be me telling you in a first step how horribly unclear and uncertain the world is. Then in a second step, it's me giving you some pointers on how you might be able to deal with this uncertainty and how you might be able to make life as a crypto litigator just a little bit more bearable. I will mention a couple of cases and articles along the way. You do not need to note this down. I mean, as Filippo said before, I'm doing a newsletter on crypto disputes, and I will share the bullet points of my presentation with the next newsletter, so you can just download it then. For starters, I'm not sure whether I need to tell you what a DAO, a decentralized autonomous organization, is, because I think just 2 or 3 weeks ago we had Stefan Daniel giving us a very detailed presentation on this. Just to make sure that I do not lose anybody on the way. It's a form of organization that is quite popular in the Web3 space. Generally, it's DAOs are member-owned communities without centralized leadership, so they have a decentralized structure, and their rule of governance, they're encoded in a computer program. Decision-taking and management is based on token holders' participation. So the members of a DAO, they usually have a governance token that identifies them as a member, although the members themselves, they are anonymous within the organization. I mean, this is the entire point of the crypto ecosystem, that you do not need to reveal your identity. There is one important distinction when it comes to DAOs that you really need to understand before we dive into the dispute side. It's that there are 2 types of DAOs, basically. There's the incorporated DAOs. So for example, a Wyoming DAO LLC, or at least a DAO using a rep entity, an incorporated, a limited liability corporation, for example, when they contract with third parties. With these incorporated DAOs, we have less of an issue. The DAOs that are really interesting from a disputes perspective are the unincorporated DAOs, so the DAOs that have no legal structure in the traditional sense whatsoever. Now, what kind of disputes have I seen in the context of DAOs? There are three types of disputes that I think we can identify. There's the governance disputes that occur between members of a DAO or between a member and the DAO itself. They usually pertain to issues of governing the DAO, for example, a voting that has taken place where that has not been properly convened. Then we see investor disputes between DAOs and investors or potential investors. For example, for the violation of a representation that was made in a token purchase agreement. Third type of disputes that I've seen are disputes between DAOs and third parties, for example, service providers or cooperation partners. In this context, you might also see disputes between one DAO and another DAO. What I see happening in the future is that DAOs will also appear in metaverse disputes, because you do see that some metaverse platforms, for example, Decentraland, they are operated by DAOs. So DAOs might also have a role to play in the future development of metaverse disputes. What makes these DAOs disputes special? I mean, why am I even giving you this presentation? And more importantly, why are you still listening to me? I mean, as I said before, DAOs, they're not a recognized organization form in most corporate laws. So it's a very difficult exercise to qualify them from a legal perspective. That's the first issue. The second issue is that the members of a DAO, normally they're anonymous and they're spread all over the globe. I mean, DAOs can potentially be joined by anyone from anywhere in the world. It's as international as it gets. And finally, they are decentralized. This means that there's no one single connecting point to the real world or to a specific jurisdiction. From a private international law perspective, this raises a plethora of issues that you can write probably 5 doctoral dissertations just about that. Now, these 3 issues that I mentioned, they lead to several legal problems that you will regularly or almost always encounter in a DAO dispute. First, you ask yourself, where do I even sue? Is it in court? Is it in arbitration? And if it's in court, who has jurisdiction? As I said before, due to the decentralized nature, this is basically a private international law nightmare that you find yourself in. And I'm not going down that rabbit hole today in this presentation. But if you're really interested in this, there's a phenomenal paper written by Guillaume and Riva from the University of Neuchâtel, where they really do a very deep analysis of the private international law issues. And their basic conclusion is that the private international law system that we have in place today, it basically does not work for crypto or for DAO disputes. Another issue that you always have is, how do you even serve court documents on a DAO? Because generally speaking, a DAO does not have a postal address. And if you live in a civil law country, for example, Switzerland, a court will have some troubles understanding that there are entities out there in the world that do not have a common postal address. Then, of course, usual question, how do you enforce a judgment or an award against a DAO? How do you tie certain assets to a DAO? But now the real big issue, and I've saved it up for last, and it's what I'll be talking for the next 10 minutes. It's, does a DAO have standing to bring a suit, or does it have standing to be sued? So in essence, can you sue a DAO or not? That's the big question that always comes up when I'm involved in a DAO dispute. And looking at this issue of standing to bring suit or standing to be sued, I mean, we will first look at how national laws currently deal with this issue, if at all. Then at the end, I will look shortly at the private international law issue that we have in this area. Now, let me start with a short peek into the future, because maybe if we're lucky in a couple of years, this is a non-issue. Because if you probably you're aware that there is this model law for DAOs that has been published by Koala, and it addresses the issue of standing to be sued and standing to bring suit of a DAO. And it basically says that if the DAO complies with all the requirements set forth in the model law, it does have legal personality, and it does have the standing to bring suit and to be sued. That's in Article 2.1. Unfortunately, we're still quite far away from global implementation of this model law. So for now, we find ourselves in a mess. Let's look at how different jurisdictions tried to solve this mess. If we look at common law jurisdictions, what you will see is that unincorporated DAOs, they have been qualified by courts so far as either general partnerships or unincorporated associations. As such, you can sue directly a DAO. A DAO does have standing to be sued. The relevant cases here, were both decided by a California court. One is called Sarkuni versus BSEX DAO, and the other one is CFTC versus Oki DAO. Importantly, although in these cases it has been held that a DAO has standing to be sued, you as the claimant, you still have the option to not only sue the DAO, but also to sue directly the members of the DAO. So you're in a very privileged position of being able to choose or to sue both of them. Civil law countries, on the other hand, I'm not aware of any decision so far that has given a definite qualification of a DAO. In Switzerland, and I think in most other civil law countries as well, a DAO is most likely to be qualified as a simple partnership, this is basically just a multi-contract model. As such, a DAO does not have legal personality. It is not capable of holding any rights in its own name, and it does not have standing to be sued. It's the members of the DAO, it's the members of this simple partnership that hold the rights together and that are jointly liable for all debts of the DAO. So the members are the ones who would have to bring an action together, but it is also the members who would be the respondent in a suit. Now, if you're representing a client that wants to sue a DAO in a civil law country, you say, great, I can simply sue the members. I know how you sue a private individual. I've done this thousands of times before, and I will do it 1,000 times again. Well, there's a very small issue here. These members, they're generally anonymous. You don't know who you need to sue. And what happens usually at this stage of a case is that you really need to do some investigatory research. You need to try to trace the wallets of the members. You need to check the discussion boards on GitHub or on Discord. You check social media. You try to identify the founders. Maybe they have been active in the news because they were trying to gain momentum with their DAO. They were trying to raise funds. And if you're lucky, you're able to identify one of those poor members or several of them, and you're going to sue them directly for the entire claim. So what we've seen so far is that whether a DAO has standing to bring suit or not, or to be sued or not, that mainly depends on the applicable law. Are we in a common law jurisdiction? Are we in a civil law jurisdiction? If yes, which? How do we determine the applicable law? I mean, this is the big private international law question at this point, because generally we speak of the lex societas, so it's the law at the place of incorporation that determines whether an organization has legal personality or not. But there is no place of incorporation with the DAO. Equally, there's no place of administration or management that you could pinpoint to one single jurisdiction. As I said before, DAOs are by nature decentralized, so they do not have one main link to a jurisdiction. This is, again, read the paper by Guillaume and Riva from the University of Neuchâtel. They do a beautiful analysis of that problem. It's a hole with no end. It simply does not add up. What I've tried before when dealing with this issue, once we knew the founders, we simply said it's the residence of the founders. Another time we tried to argue that it's the hosting of the website that is decisive. Quite frankly, I'm not 100% convinced that this would fly in court, but you need to try and find a link to the real world where you can say this is the jurisdiction with the closest connection. So since I have 5 minutes left, let me give you an interim conclusion at this point. What we've seen so far is that we don't know anything, basically. You don't even know the law under which a court is going to assess the standing to be sued. And even if you knew the law, it will rarely be straightforward. It will rarely be straightforward answers. So there's let's be diplomatic and call it, there will be a mild degree of uncertainty at this point. Now, I promised you that I will give you some pointers on how you can deal with this uncertainty. And I'm simply going to tell you what I do in practice with these kind of cases. I mean, what you do, you try to include as many potential claimants or defendants in a suit. Something I would not do in any other industry. I would try to increase the field of parties. So what you do is you try to find any possible member of the DAO. As I said, you go on social media, you check the discussion boards. I mean, once I got lucky and the person on the discussion board of the DAO had a picture in there. And when I did a reverse Google search of that picture, I found his social media profile. That was very lucky. And suddenly we were able to identify one. Sometimes you get lucky with the founders, because if the DAO gains some traction, usually the founders, they want to get some of the spotlight, they do interviews, you find them on YouTube or elsewhere. So you have another person. Sometimes you're lucky and you have the DAO as a legal wrapper. So probably at the time when you signed the contract with the DAO, they did not yet have a legal wrapper, a wrapper entity. And later on, they founded a wrapper entity because probably they found a lawyer who's told them, please get a wrapper entity. Then you might be able to also include that entity into your suit. Of course, you're also going to put down the DAO itself as a party. As I said, the more the merrier. Then when you finally assembled the group of potential defendants, what you do then is you make a very concrete threat of a suit or you file the suit. And this usually then triggers negotiations with the DAO, because the DAO, they have to intervene at this point because they cannot have a single member being sued for $20 million. Because what happens then usually is that this poor member goes onto the discussion board and they tell them what's happening, and everybody starts panicking because suddenly all the other members realized, oh, Nino is looking for potential members that he can sue. It's time for me to get out. And if the governance token is traded, everybody tries selling the governance token, and the value of the token only knows one direction, it's going down. So you can put quite some pressure on the DAO. Then usually they start negotiating with you. Maybe you are able to find a direct settlement with them, or you're able to agree on arbitration with the DAO, and the DAO will post security for the potential award. This gives you finally some leverage, and it allows you either to find a direct solution or at least to structure the dispute resolution process. And a general word is, if ever possible with these disputes, general crypto disputes, try and go to arbitration. Because the experience that I've made so far in court proceedings has not been great. Because generally speaking, the expertise is not yet there with the courts. Whereas with arbitration, you have the possibility to choose at least one of the arbitrators, and you can make sure that this arbitrator has some knowledge of Web3, crypto, or DAOs. So as you've seen, there's a lot of uncertainty when it comes to disputes with DAOs, but they can also be great fun because you as a lawyer get to be very creative. So giddy up and have fun with more DAO disputes.
Well, definitely sounds like a challenge. We have some questions in the chat. Those the questions, if you want to just turn on your microphone, you can ask the questions yourself. Otherwise, I will read them for you. So we have one from Masha. Many thanks for the insightful presentation. I just want to ask, what do you think about a worldwide regulator organization that can make some rules for some new platforms that are used more these days and are execute metaverse, smart contracts, or some agreements which they have some legal consequences?
I mean, having a worldwide regulatory organization would be great if it's accepted by all states worldwide. But I think this is it's a dream and it will never come true. What I see happening for some disputes is that will be completely detached from the court system. I mean, they are these decentralized justice protocols like Kleros. That might be an option, but for them you have an enforcement issue, and I think their scope is limited. I mean, they mainly come into play when you really have a binary question, a dispute where it's yes or no. But this is certainly I'm more hopeful for these decentralized justice protocols than for a regulatory organization that is accepted worldwide. But that is a personal view, and if we're lucky, I'm wrong.
I'll jump in with a question here about the applicable law. I know that the English courts have developed an interesting approach, especially when the defendants are not known, so they are anonymous. They've considered English courts to be competent and English law to apply to the dispute, because the assets are held in a wallet that is owned by an English resident, and that for them was enough. So my question is, do you think that is a viable approach, or is just something practical that courts have to do because there's nothing else there? And
I mean, on the one hand, I think it's a very practical solution. I think it's also a very English solution, because the English courts above all, they're very pragmatic. On the other hand, I mean, as soon as if it's a private person, you can ask the question: is it a consumer? And once it is a consumer, it's not very far-fetched to say that there's jurisdiction at the place of the consumer, and the law at the place of the consumer should apply. So I think it's not just a pragmatic approach. There's also an underlying legal rationale for this approach.
And when you have to sue, oh, we have another question. So Jonathan is asking, in practice, do you see DAOs agreeing to arbitration after the dispute has been commenced or notified?
Yes, I've seen that, especially if you try and sue them in a random state court where English is not the main language. They're generally interested in getting it to arbitration, and also the confidentiality that you get in arbitration is something that they're quite interested in.
Very interesting. Atuli asks, we have also a hand up, but let's go in order. So Atuli asks, you mentioned that stakeholders of DAOs maintain anonymity. I was wondering how so. Do you mean they keep anonymity from the public or even within the organization? What happens in cases when they have to establish a company or engage in financial activities? They would have to reveal identity, or do they conduct all the activities with non-custodial wallets?
Yeah. I mean, within the organization, you can keep the anonymity, but as soon as a DAO wants to open a bank account, there needs to be some form of KYC. And usually, I mean, depends on how proper the DAO is set up. But what I've seen in practice is that the founders of the DAO simply set up everything in their own name. Then they carry out the activities via their own accounts, which is, of course, not the best option that you have. I mean, I personally, I'm a disputes only lawyer, so I do not set up DAOs for my clients. I send them to other lawyers who are much more capable in that area. But usually at some point, if you go to a lawyer with your DAO and the lawyer is worth his salt, he will tell you set up a legal entity, a rep entity, and usually then you have all your contracts going through that rep entity. And also, I mean, the issue that I just told you, the standing to be sued, becomes much less controversial once you have a rep entity.
Very interesting. Godslov, if you want to speak, please go ahead.
Right, thank you. Thank you for the session. I just wanted to ask a simple question. As a lawyer who wants to specialize in Web3 disputes, are there any special skills you need to learn?
Sure, Godslov. I mean, you should be aware more or less of the Web3 industry, because I think it's quite unique. And there are still not that many disputes lawyers out there who have both a disputes background, but also an understanding of the technology and an understanding of the industry. I think what you should continue to do is to always attend the Web3 Tuesdays, because I think they give you a very good insight into what's going on.
Okay, thank you.
Another question from Kevin. He asks, the disputes that you have seen, were they primarily between DAOs or between DAOs and individuals or corporations?
They were primarily between DAOs and individuals or corporations. I've only seen one dispute between two DAOs that was settled very early on. And I'm very glad about that, because this would have been a nightmare.
Yeah, I can only imagine. Okay, next question. Dirk asks, related to standing and the issue whom to sue, given the uncertainty combined with the issue of tracing assets linked to a DAO, don't you see a trend that members are being sued? My perception is that specifically in the wake of crypto winter, often individuals, senior employees, developers, instead of crypto businesses more generally, are being sued.
I 100% agree with Dirk, because I mean, if you have the choice between, as I said before, under California law, apparently you have the choice. You can either sue the DAO or you can also sue the members. And if you know that the DAO is basically dormant or is inactive, doesn't have any assets left because their token is basically gone, I'd much rather sue the founder that is showing me his Rolex on his Instagram channel. So I 100% agree with Dirk, and it's been one of the strategies that we went after, is to try and get the individuals. And also, I mean, as I said before, once you start negotiating about a possible dispute resolution process, we try to insist that the DAO needs to bring some kind of security for the eventual award. This can be an escrow solution, or but there are other options as well.
Very interesting. And that is, of course, when you have the option, because sometimes you don't have the option because the DAO does not have legal standing. So the only option you have is to go after the founders or whoever you can find. Okay. Well, I guess we covered all the questions. There were a lot of thank yous that I didn't read in the chat for you. I joined them for sure. It was a very interesting presentation. As I said, it's recorded, so it would be available for everyone on YouTube. And well, just thanks a lot for your time, Nino. I really enjoyed it, and I hope
Thank
that
you,
everyone
Filippo.
else did.
Right. Bye, everybody. Take care.
Bye.